Hello everyone and welcome back to our very first session of the Spring 2024 series of Tuesday Times Roundtable. Today's session is Judicial Review and Democracy, Allies or Enemies. My name is Michelle Zaldivar. I'm your Program Manager here at the Office of Global Learning Initiatives. TTR is our flagship discussion series that brings together multiple perspectives on current global issues and trends. You can learn more about TTR, watch past recordings, or come back and reference this one at go.fiu.edu/TTR. As a reminder, please take a moment to sign in. This QR code that was posted in the front and is repeated for you right here is where we take attendance and we report attendance back out to whatever method it is that you're trying to capture, Panther Connect, your professors, all of that jazz. So please take a moment to sign in. And as we engage today, we have so many visitors. As we engage today, we ask that you please make sure that we use one of the mics when we're asking questions and engaging in discussion. We'll have 2 roaming mics on either side of the room. If we don't speak into the mic, then we won't capture it on the recording. So in order to honor everybody's contributions to the discussion, please make sure that you have a mic when you do so. Tuesday Times Roundtable is always kind of linked to a New York Times article, and that's because you, as part of the FIU community, have free access to a digital subscription of the New York Times. So you can read today's article at go.fiu.edu/TTR0206, but if you haven't already, you'll need to activate your subscription. You can do so at accessnyt.com. Make sure you use your @fiu.edu email address when you register, and you can get your free subscription. If you're here for Medallion, your Global Learning Medallion student, TTR is and always will be 1 point. Make sure to take a screenshot of the confirmation page of your sign-in so that you can use that on the verification column of your points log. If you want to learn more about the student programs that we have here at the Office of Global Learning Initiatives, including the Global Learning Medallion, Peace Corps Prep, and the Millennium Fellowship, highly encourage you to follow us on Instagram. We are @GoGlobal. This QR code will also take you straight there. And we can always hang out after the session and ask us some more questions. We've got a full-out team for you here today, so I'll do a couple shout-outs. One program that we're just kind of sponsoring or helping out with promotions, and we highly encourage you guys to go, is going to be an Afghan art show. This is being sponsored by or organized by one of our Global Learning Fellows on campus. So it's this Saturday, February 10th from 3 to 7 p.m. It's at the Frost Museum, which is the art museum right across from Blue Garage. Highly encourage you to come out and support some of the student programs and get some art exposure from something that you may not have seen before. Okay, so today's session leader has very close ties to the Office of Global Learning. So before I introduce her, I want to just take a moment to do a shout out because we've got so much of the Office of Global Learning team here to support for our very first session this series. We have our Assistant Vice President of the Office of Global Learning Initiatives, Dr. Hilary Landorf. Next to her, we have Rola, I'm going to say her last name, Zar. I say yes. Next, we have our Senior Program Coordinator at the Office of Global Learning Initiatives, our newest addition to the team. We have Janeri Mendoza. Out in the foyer, when you were welcomed in, you were welcomed by Connie Penchak. She is our new Assistant Director of Student Programs. And Gitanjali Jathu, who is our graduate assistant that works on the curriculum and faculty side. But to introduce our speaker with very close ties to our team, I want you to join me in welcoming another graduate assistant in charge of all things comms, including drafting your newsletters and answering your DMs on Instagram, Natalia Bocci.
Hi, everyone. I would like to introduce our speaker today. Dr. Viktor Kazai is a Hungarian lawyer specialized in comparative constitutional law. He obtained his doctoral degree from Central European University in Vienna. Viktor currently holds a postdoctoral research position at the University of Brussels and supports the work of the Berlin-based NGO Civil Liberties Union for Europe as a senior rule of law expert. In addition to his participation in several international projects focusing on challenges to constitutional democracy in the European Union, Viktor has been involved in human rights litigation as a legal advisor, most importantly before the European Court of Human Rights, and in collaboration with human rights NGOs. He joins us today as an international law specialist and law expert, but I am most proud to call him my uncle. Please join me in welcoming Dr. Viktor Kazai.
Thank you. Thank you very much for the kind introduction. I'm also very proud that you are my niece. Thank you very much for having me. It's a pleasure to be here. Today I'm going to talk about a topic which sounds very abstract, judicial review and democracy, whether they are allies or enemies. But I promise you that I will try to bring this very abstract topic as close as possible to political reality. But I'm a lawyer, I cannot help it. Sometimes I use language which is not necessarily accessible to an audience, especially if they're not lawyers. So whenever I say something which doesn't really make sense, then just ask me, okay, for any kind of clarification. Alright, so let me go through the points of discussion of today, because I tried to make this presentation as participatory as possible. First, I will discuss very shortly why we think, usually in a society, and lawyers especially, that judicial review and democracy are enemies, that there is some antagonistic relationship between judicial review and democracy. I will give you a controversial moral issue, as an example, which was decided by the court, and I will ask you whether you think that this kind of moral issue should be decided by courts or instead legislatures, parliaments. Then we will discuss very briefly the democratic legitimacy of parliaments and courts. And in the second part of the presentation, I will try to convince you that courts are actually not the enemies of democracy, they are the allies of democracy, or we can conceptualize the relationship between courts and democracy as a mutually supporting relationship. I will give you 5 examples or 5 ways in which courts can actually promote democracy. And finally, I will talk about the scrutiny, the judicial scrutiny of parliamentary lawmaking. And hopefully by the end of this presentation or discussion, you will be convinced that courts are the natural allies of democracy and not the enemies of democracy. So, as I promised, let me start with a very, very controversial case decided recently by the Supreme Court of the United States, Dobbs v. Jackson, 2022. I'm pretty sure that you know about this case, maybe not the name of the case, but you heard about this case of the Supreme Court. Does anyone remember that? Do you know this case? What was this about? And if I say abortion, does this ring a bell? Do you remember maybe the facts of the case, like why people went to court in the first place? Okay, so in 2018, Mississippi passed a law prohibiting abortion, except for a few exceptions, prohibiting abortion after the 15th week, because they said that this is the time when the fetus is viable, like it could live outside of the womb. And from that moment on, abortion is prohibited as a general rule. Again, a few exceptions. Jackson Women's Health Organization went to court, challenged the law at court, arguing that this is unconstitutional. The district court in Mississippi found the law unconstitutional. It said that Mississippi didn't prove that the fetus would be viable at the age of 15 weeks, and also that previous decisions of the US Supreme Court, most notably Roe v. Wade and Planned Parenthood v. Casey, said that there is such a thing as a right to abortion in the US Constitution. That's why adopting law which violates the right to abortion violates the Constitution. That's why the law is unconstitutional. So the Mississippi District Court said that this law is unconstitutional and prohibited the state of Mississippi to enforce the law. Now, Thomas Dobbs, who was an officer, a health officer, was not happy with the decision. So upon his petition, the case went all the way up to the US Supreme Court. And the US Supreme Court decided, what? Do you remember what was the big scandal of last year? Is there such a thing as a right to abortion according to the US Supreme Court? No, not anymore. It basically said that Roe v. Wade and Planned Parenthood v. Casey, those previous cases which recognized the right to abortion, even though it was not mentioned in the Constitution, it's not mentioned in the US Constitution, the right to abortion. It was a judicial invention, let's put it that way. The US Supreme Court read the right to abortion into the text of the Constitution. So in Dobbs v. Jackson, the US Supreme Court said that this was a mistake. There is no such thing as a right to abortion. It didn't say that abortion as such is unconstitutional. It simply said that the authority to regulate abortion must be returned to the people and their elected representatives. In other words, it's not for the court to decide whether there is such a thing as a right to abortion. It's for the legislature, it's for the people and their representatives to decide whether there is such thing as a right to abortion. So, my question to you is, what do you think? Based on the principle of democracy, okay, and let's focus on democracy right now. Would you prefer to delegate the right to decide on abortion to a legislature or to a court? Again, I'm not asking you whether you agree with the right to abortion. I'm not asking you whether you morally accept it or not accept it. What I'm asking you is whether the right to abortion is a moral issue which, do you think, should be regulated by the legislature, the parliament, Congress, or this is a question that should be decided by a court, and if so, why?
I had to give it a little bit of thought before I answered, just because I didn't want to offend anyone or didn't want to, breach into anybody's beliefs. But I think what's interesting about either it being legislature or going into court is that if it goes to court, I think it would be on a case-to-case basis.
Mm-hmm.
So the answer wouldn't be, or it would be different for everybody, right? But if it goes to legislature, then it's set and that has to be what everybody should follow. And I think in this case that it's so case-to-case basis, in my opinion, that's why it should go to court. Because everybody's experience and everybody's beliefs are different. So that's why it wouldn't be as a legislature, rather in it going to court.
Mm-hmm. So if I rephrase it a little bit, you're basically saying that a court decision cannot represent as many views as there are in society, and that's why it's more particular, more specific than a general law adopted by Congress or any other legislature.
Yeah, and I think that's why it hasn't happened yet. It's just because this topic is so broad and there are so many different experiences that somebody could have and so many different situations that could play into the decision of yes or no. And that's why there hasn't been a legislature, because there's no way that you can cover all those bases.
Okay. Yeah. Thank you. Well, in the US, I would say. There's no in the US. All right, thank you. Anything else? Any other idea? Why would we think that deciding this case by a legislature is somewhat more democratic than going to court and asking the Supreme Court or any other apex court to decide this case? Why do we usually think that legislatures are more democratic than courts? And they are better placed in the constitutional system to decide on morally controversial issues?
I would say, I feel like, to answer your question, most likely because legislators are voted in, as opposed to the court is appointed to that position. So their decisions might not be representative of the country, such as, I know in this scenario, I don't remember the exact numbers, but I think the majority of Americans in general, based on surveys, are in support of abortion. Or even with the other, I don't remember the name, But the other similar court ruling that happened in 2022 that had to do with like gay marriage and stuff like that, like businesses not having to like take gay customers. Also, like the majority of Americans are also in support of gay marriage being a right. But then in these two instances, the court kind of went against what the people want.
Thank you very much for all the input. Yeah, so people and lawyers especially think that when it comes to democracy, it's better to allocate the right to decide on morally controversial issues to legislatures because they are directly elected by the people, or at least one of the houses is directly elected by the people, whereas courts, they are indirectly appointed, right? They're not elected by the people themselves. They are usually selected by the legislature together with the executive. The other thing is that a court is a relatively small institution, right? Like a small number of people participate in judicial lawmaking, and they are selected based on their expertise, their knowledge, and not necessarily because they represent a particular view that people agree with. When it comes to legislatures, it's a very large institution. It's a big institution with tens, if not hundreds of people. They can better represent society. And they are selected on the basis of their political views, on the basis of their fitness to represent characteristics of their constituencies, opinions, and so on and so forth. Also, when it comes to accountability, elected representatives are directly accountable to the people. Judges are not directly accountable to the people. You cannot fire judges just because they make bad decisions or decisions that you do not agree with. And lastly, when it comes to the decision-making process, when courts make decisions, it's less transparent. You do not know what's happening in the chamber, and they focus on legal considerations. They have to. This is their job, to focus on legal considerations. Whereas in legislatures, ideally, of course, it's more transparent, unless, of course, there is some lobbying behind the doors. And legislatures can take into consideration all the factors, all the opinions that they want. They are not restricted to legal considerations. They can make decisions on the basis of every consideration that they find appropriate. So that's why many lawyers think that when Supreme Courts or constitutional courts say that a certain piece of legislation adopted by the legislature is unconstitutional, it is undemocratic. Because, as Alexander Wickel said, some American scholar, when the Supreme Court declares unconstitutional a legislative act, it thwarts the will of representatives of the actual people of the here and now. It exercises control not on behalf of the prevailing majority, but against it, against the majority. So that's why courts are very often considered to be anti-democratic institutions. But I would like to argue that yes, it's true, there are certain cases, especially in morally very controversial issues, when courts strike down legislation adopted by parliament, adopted by the majority, and this is sort of anti-democratic. But there are a lot of things that courts do which are very pro-democratic. It is not against the majority, it's not against the democratic will formation, it is to support, to enforce the democratic will formation in society. I'm thinking about whether I should go into a little bit of constitutional theory, but I think we can skip that. I was going to talk a little bit about American, German, and Austrian, very old, very dead people. No, I'm sorry, Habermas is not dead. Habermas is not dead. But we are going to skip that. And instead, let me just summarize why I think that when courts exercise judicial review, they can support democracy. First of all, when courts review what legislatures do, the outcome of the legislative process, they can promote democracy in 5 ways. First of all, they can strengthen those rights that we have as individuals, which enable us to participate in democratic will formation. These are the so-called political fundamental rights or political participatory rights. Any idea what this big category of political participatory rights may include? What are the most well-known fundamental rights that you have, that we all have? Enshrined also in the US Constitution, although the US Constitution is notoriously short, but even in the US Constitution there are these political rights. Yes? Oh, I thought you, sorry, I thought you.
So any right based off the Constitution alone?
Yeah, exactly.
Oh, the right to property?
The right to property?
To own property?
Okay. In what sense does this allow you to participate in democratic will formation?
Oh, that's a good question. Well, I guess to perform having property means having a place to keep your items secure, to have a place to sleep in, and ultimately, ideally, have access to like food and things like that, and gives you a space to then go out and participate in the world.
Mm-hmm.
I know that sometimes owning property means you also have to see what's going on in your area. You pay taxes on your property, and so ideally, that gives you some say as to what happens in the land that you're a part of.
Mm-hmm.
Additionally, that's my thoughts.
Okay, that's a good idea. Thank you.
I also have one, but you go first.
Oh, you go first. Go.
Free speech.
Yeah, freedom of expression or free speech. That's a very, very good example.
Yeah. I was going to extend on the First Amendment and say freedom to assembly and to petition.
Exactly. Freedom of assembly, freedom of association. This is how you can express your opinion. This is how you can express your opinion individually or with other people. This is how you can create associations, even political parties, and participate in the democratic process. Okay, so whenever the Supreme Court or a constitutional court protects your free speech, freedom of assembly, freedom of association, or even the right to property, it enables you to participate in one way or another in the democratic will formation of society. The second way is guaranteeing media freedom and media pluralism. I think it's quite obvious that media is the #1 platform where we communicate our ideas, we get our information about politics, where information is disseminated in society. Of course, we do it personally as well, but in general, we read the articles, we watch television or social media platforms. This is how we communicate nowadays in modern societies. The third one is guaranteeing the fairness of elections. So it's not enough to have elections on a regular basis. It doesn't matter if elections can actually express, or the result of the election can actually express the will of the people. It's very common, unfortunately, nowadays, even in Western democracies, which are considered to be well-established democracies, to manipulate the electoral system in one way or another, so that those people who are in power can make sure that they will be re-elected. Okay, unfortunately, this is not uncommon. And whenever the Supreme Court or constitutional courts, they review the electoral regulation, they can make sure that the elections are fair, so that the people can outvote the government that they do not agree with. The fourth one is fostering integrity and transparency in public life. What I mean by that is that ideally, again, politicians have to comply with certain ethical rules. And certain ethical rules are fortunately also enshrined in law. Like, for example, when they are members of Congress, they cannot do certain professions, or they cannot have property in certain companies or organizations. These are called incompatibility rules. Also, lobbying. To a certain extent, lobbying is a perfectly acceptable way of trying to influence the legislature. But if it's not transparent, if you do not know which lobby organizations do what, and which members of Congress and members of Parliament are approached by these lobby groups, well, this is really against democracy, because this is not transparent and they are not accountable. And the last thing, and this is what I would like to talk about in the rest of the presentation, is scrutinizing the parliamentary decision-making process. This is what I think probably the most important way in which courts support democracy and not block democracy. So, whatever happens in Congress or in Parliament, we often think that this is a matter of politics, right? They're making political deals. They are trying to arrive at political compromises. So whatever happens between politicians in legislatures, it's a matter of politics and not a matter of law. This is an area where the law cannot enter. But this is actually not true, because one of the oldest principles of law is that every single exercise of state authority is and must be regulated by law, including the legislative process. So just because it's a political process, it doesn't mean that it's not regulated by law. It is regulated by law. What is more, the legislative process must comply with certain requirements. Certain requirements which are enshrined either in the national constitution, like the US Constitution, or in international legal instruments, international treaties, international covenants. Most of these requirements derive from the principle of democracy, the principle of separation of powers, or the principle of the rule of law. Now, what kind of requirements am I talking about? I brought you two examples. The Venice Commission. Any idea what the Venice Commission is? Have you ever heard about the Venice Commission? It's in Venice. The Venice Commission is an advisory body of the Council of Europe. The Council of Europe is an international organization which assembles many countries of Europe, broadly speaking, and it tries to set certain standards with which every European country must comply. And they published in 2016 a rule of law checklist, and in that rule of law checklist they also talk about the legislative process. What are the minimum requirements of the legislative process that every member state of the Council of Europe must comply with? And they say that the process of enacting laws must be transparent, accountable, inclusive, and democratic. So it's not enough that some bill is introduced in Parliament and then just members of Parliament or members of Congress just adopt it in the way they think it's fine. No, the whole process must be transparent, it must be accountable, inclusive, and democratic. The European Commission, which is more or less the executive of the European Union, has a very similar understanding of democratic lawmaking. It says that the rule of law includes, among others, principles such as legality, implying a transparent, accountable, democratic, and pluralistic process for enacting laws. So these are some of the requirements with which parliamentary lawmaking or congressional lawmaking must comply with, even if members of Congress or members of Parliament do not find them particularly appealing. Now, the violation of these requirements actually lead to unconstitutionality. So, if a piece of legislation is adopted in Parliament, but the parliamentary process is not democratic, it's not transparent, it's not inclusive, it's not accountable, it's not democratic, it should lead to unconstitutionality. That piece of legislation, no matter what it contains, no matter whether it's a good law or a bad law, should be declared unconstitutional because the process in which it was adopted was defective, because it did not comply with these minimum requirements of parliamentary lawmaking. And when something is unlawful, something is unconstitutional, it's the role of the Supreme Court, constitutional courts, to declare that law invalid. This is how courts can enforce the Constitution, the procedural requirements of the Constitution. Okay, now I know that this was very abstract, but I will try to bring this very abstract argument a little bit closer to political reality. So I will give you a couple of cases in which Supreme Courts or, yeah, sorry.
Before you do that, could you? Of this.
To that kind of judicial review?
Yes.
Yes, thank you very much. This is a very good question because there is and there isn't. In certain states, Supreme Courts do exercise that kind of review. If I'm not mistaken, the Supreme Court of California does that. But it doesn't exist on the federal level. So the federal US Supreme Court doesn't do that. It does sometimes decide cases in which the question is whether a particular political decision should have been made by Congress, or it was fine that it was decided by the executive or by regulatory agencies. So this is the closest that the US has for this type of review. But otherwise, the US Supreme Court does not review what's happening in Congress during the congressional legislative process. I'm not aware of any decision in which the US Supreme Court would have said that a certain piece of legislation adopted by Congress is unconstitutional because the process itself was so defective. But this kind of review exists in many, many other countries, even in Anglo-Saxon countries or countries which follow the common law tradition.
Could you go back to the last slide? The other question I want to ask. Transparent, accountable, inclusive, and democratic, how those are interpreted, how those words are interpreted, even in the areas where they're enforced. And I'm thinking again of the United States and Congress, and bills that are presented. Say you have 1,000-page bill that's presented, and people have 12 hours to read that bill and make decisions on it. How is that transparent or accountable or inclusive or democratic? So how are these words interpreted?
Thank you. Well, I wish I could give you one answer that would be true to all the countries. Unfortunately, or not unfortunately, these principles are interpreted differently in every jurisdiction where this kind of judicial review exists. There is no general European approach to this kind of thing, especially because constitutions very much are very much different to what extent they regulate the parliamentary legislative process. Some constitutions only have general principles, democracy, rule of law, that's it. Other constitutions, for example the French Constitution, regulates the legislative process in details, from the very beginning until the very end. They do not need these BRIC principles because basically everything or every important step of the process is in the constitution itself. In other countries, for example Hungary, the legislative process is not regulated in details in the constitution, so that's why very often the Constitutional Court needs to interpret such general principles as the rule of law or as democracy in the lack of any more specific rules. But actually, one of the cases that I will talk about talks about this omnibus legislation. So, but let me first start with the Hungarian church law case. It was decided in 2011, and according to the facts of the case, in 2010, the then Hungarian government introduced a law in parliament. This was a so-called church law. The rationale behind this law was that the government thought that many religious organizations, they created so-called business churches. They created churches just in order to get tax exemptions. And that's why they really wanted to re-regulate the whole sector. They basically deprived every single church of their church status and obliged them to reapply for church status, but this time not before the court, but they had to apply to the National Assembly or to Parliament. So it became the prerogative of the Parliament to give church status to religious communities. Now, the Hungarian government knew very well that this is a very controversial piece of legislation, most probably even unconstitutional. So what they did is that they introduced the first version of the bill, which was somewhat controversial, but it was still okay. And members of parliament, the media, members of civil society, basically everybody, was discussing that version of the bill for weeks and months. And when it came to the final vote in parliament, so the very, very last moment of the legislative process, they completely rewrote the bill. They submitted so many so-called last-minute amendments, so last minute meaning that it was the last minute of the legislative process. They submitted so many amendments that the version of the bill that was finally adopted had not much to do with the original version of the bill. Many churches went to the Hungarian Constitutional Court arguing that this church law is unconstitutional because the legislative process was unconstitutional. Now, what do you think? What were the reasons why the Hungarian Constitutional Court said that, or what would you say that what is the reason why this kind of legislative process is unconstitutional, and that therefore the church law that was adopted as a result of this process should be invalidated because it's unconstitutional?
As you said, so many of the changes were last minute that it didn't allow people and citizens to have an opinion on them and decided they wanted to vote against it or be in support of it. And I think that's the main point that I wanted to make.
Yeah, that's basically was the main reason why the Hungarian Constitutional Court actually invalidated the law. It said that last-minute amendments can be used. It is absolutely possible that in the very last minute, the parliamentary majority thinks that, oh God, we forgot something. We have to put it in the bill. We cannot adopt the bill without that specific article in the law. But you cannot use last-minute amendments to completely rewrite bills, because it basically means that the legislative process, the parliamentary debate, the social debate about the law was useless, because what you adopt has nothing to do with the original version of the bill. So that's why this law was invalidated by the court. Omnibus legislation. So in Kwantinsky versus Knesset, this is a case that was decided in 2017 by the Supreme Court of Israel. In that case, the Supreme Court was petitioned to review the so-called third apartment tax law on the basis that this was an omnibus legislation adopted in an accelerated procedure. Okay, so this is legal terminology. So omnibus legislation. Omnibus legislation is a kind of law which regulates everything and anything. It's a piece of legislation which has a very general title, and it can regulate anything from taxation to the judicial system, from public education to the right to health, basically everything. Now, why do you think that this kind of omnibus legislation is anti-democratic, especially if adopted in an accelerated legislative process? So when the whole process is not as slow as it usually is, or as it should be as a default rule.
It's not transparent.
It's not transparent because there are so many bits and pieces in the law that can be amended and modified without.
I think another one is that you end up having to make concessions in some areas to get one thing that you want. So let's say I want the part of the omnibus that has to do with health, but I don't necessarily support the part of the omnibus that has to do with education. When they're lumped together, I can't isolate each one of those issues.
Mm-hmm. Exactly. So many constitutional courts and sometimes even constitutions say that one bill should have one subject. So if it's a church law, then it should be about churches. If it's an apartment tax law, it should be about apartment tax and not anything and everything, because the process will not be transparent. Even the members of parliament or members of Congress will not be able to read everything, to keep in mind everything, to know every single part of the law. And if there are amendments, if there are political trade-offs, the whole thing just become intransparent. So that's why the Israeli Supreme Court said that the adoption of this omnibus legislation, especially in a very speedy process, was unconstitutional, because this process deprived the members of Knesset, the Israeli parliament, of meaningful participation in the legislative process. Of course, they voted for the bill. Technically speaking, it was adopted by parliament, but there was no genuine democratic deliberation in parliament. It was more like a mechanic process. Another example from Brazil. Yeah, still have a couple of minutes. Another example from Brazil from 2018. According to the facts of this case, the president of Brazil in 2012 adopted a so-called provisional measure. The provisional measure is something that only the president can adopt without the consent of parliament. It has the force of law, so it is like a law. It's like something, a piece of legislation adopted by parliament. But since it was not adopted by parliament, it was issued by the president, it has a very short expiry date. Okay, it can regulate a certain issue for a couple of months, but then it will lose its force unless it's approved by the parliament. So in 2012, the president of Brazil issued this provisional measure by which she facilitated basically the construction of power hydro plants in environmental protected areas. So basically, it was a decision that that reduced the boundaries of national environmental protection areas in order to facilitate the construction of certain power plants. Now, later on, this decision of the president was approved by the parliament, but not originally. But this provisional measure was challenged at the Brazilian Supreme Court, and the Brazilian Supreme Court said that this provisional measure of the president was unconstitutional. Do you have any idea why the Brazilian Supreme Court could have said that? Why would it be unconstitutional for a president to regulate in not a law, in a provisional measure, the size of environmental protected areas in order to facilitate the construction of power plants? Yes?
Could it be anything related to national security or like Navy or some sort of other law that's governing something that the president cannot have jurisdiction over?
Okay, so this is you are approaching this question from a separation of powers perspective. Yeah, this could be one good reason, but this is not the reason why the Supreme Court said that.
Could it be because he's possibly financially like profiting off of the project, since it's like taking away land for power plant and everything?
Yeah, it does. It does. So it does have an effect both on the budget, of course, and the environment. The whole environment in Brazil. So the logic of the Supreme Court was that the right to environment is a third generation fundamental right. Third generation, the first generation are political rights, the second generation are socio-economic rights, and the third generation are rights such as the right to a healthy environment. The right to a healthy environment, it appears in many constitutions, including the Constitution of Brazil. So the Supreme Court said that this provisional measure, it directly affected a fundamental right, the right to a healthy environment, and that's why it's such an important question that it can only be regulated by Parliament. It cannot be regulated even temporarily by the President, because it's the Parliament, the representatives of the people, who have the exclusive competence, right, to regulate such an important measure. And this is why the provisional measure of the President was declared unconstitutional by the Supreme Court. And maybe we have time for just one last example from Germany. This is the Hartz IV, the Hartz IV case, decided in 2010, so relatively long ago. This case concerned the minimum social benefits. In many European countries, there is such a thing as the right to social security enshrined in the Constitution, which means that the state must give you some money, some social allowance, not to die, at least. In many cases, however, the constitutional courts have a difficulty with finding out what is the constitutional minimum. What amount of money is enough for a person to survive? So what is the constitutional obligation of Parliament? The German Federal Constitutional Court actually came up with a very good idea how to enforce the right to social security without actually telling the Parliament how much money to give to the people. It said that the court is fine with the decision of the Parliament, is fine with every amount of money that it may give to the people, as long as the process in which the Parliament decides about the amount of money must be based on reliable figures and reliable methods. So the court must be able to verify that the Parliament made this decision on some rational basis, that it actually calculated how much money is enough for people to live. And in that particular case, the German Constitutional Court said that the Bundestag, the German Parliament, failed this obligation. The amount of the standard social benefits were not calculated based on reliable figures and plausible methods of calculation, and this is why the law was found unconstitutional. I have a couple of other examples in my pocket. But I'm gonna stop here in case you might have any questions. And I thank you very much for your attention.
Thank you. So that was really insightful and a topic that I really didn't think I'd understand too much of, and I appreciate bringing it down to my level. So it's not so much of a question as much as it's like your general opinion. We talked a lot about the judicial going into the political and the legislative process, and what kept coming to my mind was Citizens United, right? Which is the Supreme Court decision where businesses can participate in the political process as individuals, and then it brings money into politics. And then so many of the things that we're talking about whether it's legislative or by the courts, comes back to that point to me. So general opinion, whether it's right or wrong, but like on the process.
Right, thank you. Yeah, so the US Supreme Court has a couple of judicial innovations that are pretty innovative, let's put it that way, such as companies' fundamental rights. This is not very common in Europe. Well, in general, I think that freedom of expression is very often considered as the crown jewel of fundamental rights, as something untouchable, and as something that should not be regulated at all and should be as free as possible, which is fine as long as it does not affect negatively the fairness of the electoral process. And I do think that in those cases where we can detect that companies use their money to influence political decision making and electoral campaigns in a way that is unfair, I think that the freedom of expression doesn't go that far. So that would be my general answer to that. Yes, unfortunately, it's not only the US. Many constitutional courts have struggles with understanding what fairness means and how exactly to guarantee that elections are fair, in the sense that the electoral system is adequate to give expression to the will of the people. There are many problems in electoral systems, and courts should do much more to guarantee the constitutionality of this process. Any other questions, comments?
Hello. So this was very interesting presentation that you gave. This is not my area of expertise by any means, but it was easy to understand how you placed it. My question was, it was kind of interesting to see how there's a lot of different governments that kind of have this idea of a constitution and also a court that's put in place to enforce it. In your experience, are there any governments that are considered democratic but kind of deviate from this idea of having a constitution and courts to enforce it?
Right. Yeah. Thank you. Thank you very much for this question. It's very important because, of course, when I say that courts can be used or can be pro-democratic, it doesn't mean that just because there is no Supreme Court or Constitutional Court in a country which has this right of judicial review would be undemocratic. Yes, so there are many countries where there always is a constitution. Whether it's a written constitution or not a written constitution, that's a different question, but there always is a constitution. Even in the UK, actually in the UK they would say that they have a written constitution. It's just not written in one document, it's written in many books. They do not have a codified constitution, but definitely have a written one. And in the UK, there is actually some sort of judicial review now, not constitutional review, but the UK Supreme Court has the right to decide upon petition whether a piece of legislation adopted by the House is compatible with the European Convention on Human Rights. The thing is that the opinion of the court is not mandatory, it's not obligatory, it's not binding on the legislature. Okay, the legislature can always overrule basically the decision of the Supreme Court. But there are many other European countries, such as Finland, for example, or Sweden, where either there is no judicial review whatsoever, or the judicial review is weak in the sense that the Supreme Court can give an opinion on the constitutionality of the law, but cannot invalidate legislation. It cannot say that this legislation is unconstitutional, therefore it should not be applied. Whether there is a need for constitutional courts or Supreme Courts and judicial review or not depends to a large extent on political culture and on alternative constitutional organs. Finland, for example, Sweden, for example, there are so-called constitutional committees in parliament, and these constitutional committees, made of politicians mainly, some legal professionals sometimes, these constitutional committees, they have a prestige and they have the right to express their opinion on the constitutionality of laws, which will be taken into consideration by the parliament. And if they say that something is unconstitutional, the parliament will not adopt it in the vast majority of cases. So it's not necessarily needed to have a Supreme Court or a constitutional court if you have a parliament in your country which takes the constitution seriously. Unfortunately, even in well-established Western democracies, it's not always the case. Again, because parliament is very often considered to be a sphere of politics, and whatever happens in parliament is a political thing and not a legal, not a constitutional thing. But in certain countries, they take the constitution more seriously. I hope this answers the question.
Is this on? Okay, it's on. Thank you again. This conversation is certainly captivating. In the same sense, this isn't my area of expertise, but this whole idea of judicial review is very interesting and I think very important. You stated that there's no judicial review of Congress' decision-making process in the U.S. I just want to hear your personal opinion based on that statement. Do you think our system is democratic?
So the reason why there is no such judicial review in the US is because you inherited a lot of things from the UK, like it or not. And one of the things is parliamentary sovereignty, parliamentary autonomy. Congress is usually believed, Congress has never been sovereign in the sense that there has always been a written constitution, and that was the Supreme Court. And since 1803, since Marbury versus Madison, the US Supreme Court exercised judicial review. Whereas in the UK, the decision of Parliament is basically unchallengeable. It's the law. What the Parliament says the law is, that's the law. And it can always change the law. The US Congress is different because there is a written constitution and there is judicial review. But interestingly, the US Supreme Court borrowed many judicial decisions from Britain, including judicial decisions on parliamentary sovereignty. And it says that it doesn't enter Congress, it doesn't review what's happening in Congress, because this is protected by congressional autonomy or congressional sovereignty. So what happens in Congress is shielded from judicial review. And even if it wasn't shielded by judicial review, the US Supreme Court has this doctrine called the political questions doctrine. And if for some reason it thinks that the question is too political, it will not touch it. So it's highly unlikely that anytime soon the US Supreme Court would review any piece of legislation based on the process of congressional decision-making. It's not unthinkable. There are certain decisions of the US Supreme Court which hints in that direction, that it might be ready to do it, but it hasn't done so yet. No, I don't think that for this reason alone, the US congressional lawmaking process would be undemocratic. If anything, then I think the big deficiency of the US congressional process is that it's not efficient enough. And this is also detrimental to democracy. You must have a parliament which is able to adopt laws if it's necessary. And if it's paralyzed constantly because of political conflicts, then it's not an effective parliament, and therefore it's also an undemocratic parliament, because there are many important decisions that need to be regulated by Parliament, by Congress, and if Congress is unable to do so, then it is detrimental to democracy, because then the other constitutional organs, for example the President, have to think about other ways of regulating important matters. Or then Congress will start delegating very important questions to regulatory agencies. Regulatory agencies which are not as democratic as Congress. I hope this answers the question.
Alright, so that's time. I'm sorry for those of you that do schedule us between your classes. It is 1:33, so if you have to run, totally understand. Join me one more time in a round of applause. Thanking Victor. This is an absolutely phenomenal time. Thank you so much. So TTR comes back in 2 weeks. We will not be here next week, but in 2 weeks on the 20th, we'll welcome Zoo Miami to talk about how they're using their research and community reach to create community impact. So we hope to see you again, and I hope you enjoy the rest of your day.